Restriction is allowed and coming on the application. Usually I can dispose of but in the circumstances, there shall be no other aspect also.
Item number 2 for orders WPC 12863 of 2025.
Same.
The restriction stands disposal in terms of welcome pronounced today. Remember the WPC number 1-2-4-3 of 2025.
Yes, please. This has to be aligned. We will send it together.
So don't, yes,
I don't say it.
Fresh admission item number 3.
give.
Some technicalities came up while disposing this matter. Some technicality came up while disposing this matter. This
What?
matter was initially alleging the illegal appointments of retired employees in government department beyond the age of 55 years.
Oh,
Unfortunately, this case was dismissed as PL is not maintainable in service.
true.
Then it was filed as a writ.
Oh,
The court disposed of the representation. And again, it was filed for inaction of the government. But the court returned it by stating that it is a PIL.
the earlier matter, this is for implementation. Where is the earlier order? Saying that it is not PIL?
It
Page
is
number 27.
Yes?
and it's for 4 months, based on service.
Did you not brought to the notice of the judge?
It was brought to the notice of, but
Then?
maybe I failed to convince. But it's clear case where the policy decision of the government is challenged, the executive is challenged. Because there is a clear rule, and we can see.
No. The earlier judgment was that it relates to a service matter and public interest litigation is not maintainable.
Yes, ma'am.
And the PIL was filed for compliance of the provision of the Odisha High Court Public Interest Litigation Rules.
Yes, ma'am.
He is an RTI activist without following the due procedure, wasted the court's time. 20,000 deposited.
It was word. It was word.
When?
But filing another 18 hours.
Waived.
Yes, ma'am.
My brother is very, I would say, considerate.
Yes, ma'am.
I am not.
We have another very genuine cause of action. Lakhs of job aspirants are waiting, but the government is violating these regulations. It's a clear cut violation. They have admitted also. So actually, at page 19, members.
Where is the order? No. You are raising the same cause.
Yes, members.
What you raised in the PIL earlier.
Yes, ma'am.
Same thing.
Same thing.
So
According to minutes, a representation was also brought up thereafter when a substantive writ was filed. The court directed at page number minutes 29.
yes, as I have seen.
Yes, my lord. And accordingly, at page number 39 also, that was considered, my lords. And the reasons are given, my lord.
What? You have considered.
Yes, my lord.
So
My lord, that is not as per law.
true.
Yeah,
Then you challenge that
Yes,
decision.
ma'am. Yes, ma'am.
Then why PIL?
I did challenge it as a PA.
You challenge as a regular writ petition.
There are three round of litigation in this case.
First one was an PIL.
Yes, my lords.
Then the court dismissed it, say holding that it is not PIL.
Yes, my lords.
Correct? No difficulty.
Yes, my lords.
Second one, you filed a regular writ petition.
Yes, my lords.
That was disposed of, directing them to consider representation and dispose
Yes,
of.
my lords.
No. Third one, this writ petition is the third one. When you filed challenging that decision,
Yes, second decision. I'm challenged there.
not second decision, you are challenging the decision taken by the authority
Yes, my lords.
and also flagging the same issue
Yes, my
which
lords.
you flagged
Yes, my lords.
in the PIL,
Yes,
first writ petition.
yes, my lords.
So then the judicial discipline demands that you can't. If it was held that it is not PIL, then how can it be treated as PIL?
Subsequent events.
Even then, it does not render it PIL.
But the matter was not decided. So I thought a simple rate will do that.
No, that's true. We are also of the view. We are with you. Are you not understanding what we are pondering upon?
It can't be PIL other than PIL.
So I think it requires some kind of a.
The only reason I think because this order has not been challenged in the prayer minutes. Annexure 7 is
Now,
not
why didn't
challenged.
you take a policy decision in
Yes.
this?
Policy decision, but specifically this annexure is not challenged.
A particular case you have taken.
No, what is this? The office order dated 28/6/2023. What is this order? Is that challenged?
The initially challenged. That is the order allowing persons employing persons beyond the age of 65 years.
Yes. And where is the representation? What is the date of the decision taken on representation
24 2000.
on the basis of second writ?
Page number 39, madam. Annexure 7.
What is the date?
20th April 2024.
You have not challenged that. Yes, they have challenged it. Pair 2. No, that is a 14. Sorry.
14.
No, you have not challenged it. You have not challenged it. Case 39 has to be challenged.
Yes, my lords.
So, what is this litigation policy? What is this litigation policy?
I didn't get that.
You're talking about a litigation policy I find from the first PIL. That is, sorry, public interest litigation. No.
My simple prayer is that they cannot violate the General Administration Department's rule. Violating, they are engaging employees beyond 65 years.
Are they re-engaging after 65?
Yes, my lords. They have admitted also at case 19.
Let's, if I may refer,
Oh,
Malats, if I may refer to the resolution page number 13, my lords. 4, my lords.
yes.
The re-employment shall be made initially for a period of 2 years and can be extended for a subsequent period of 2 years. It tells 1 year each subject to satisfactory performance of to total.
How can you go beyond 65?
My lord.
That is his concern.
My lord, or till the post are filled by the regular process, whichever is earlier. My lord.
Sir, suppose you did not fill up the post for 10 years, then he will continue up to 75 years.
At page number 39, explanation has been given, my lords, in the representation. My lord.
How can you do it? It's a very nice, I will embrace and accept that in every sphere of service should be done. There will not be any filling up of the post and he will continue extension 1 year, 1 year, 1 year. is it not impacting the employment which has to be generated?
Employment has been generated, my lord.
How?
Page number 30.
If you continue with the person who has already retired, does it not mean that he is occupying that particular post? Can you fill up that post? What is his then? In what post he is working?
If I may only refer to page number 39 once, my lords, Annexure 7, my lords.
I understand. Tell me, madam.
Only, my lords, here the reason which have been given in the representation order is that recruitment process has been completed because that
We are not concerned. We are not concerned, madam. We are on a very basic and a foundational fact. It is immaterial. When you have given an SOP or a guideline, whatever, you says that he will be permitted to be reemployed or reengaged on a yearly basis, renewable from time to time, when until the regular post is filled up. There are instances where there is no recruitment drive for 10 years. Let us see there is no recruitment drive for 10 years. Does it mean that he will continue for 10 years, means up to the age of 75 or a 70 or a 72, means he will continue?
Let's hear the interim order is passed with Forest, also Forest Development Corporation. Well, it's, even if the notice has to go.
It reminded me my days over there. It reminded me my days over there. Whenever I'm briefed and I do not find that I have anything to say on merit, everything is against my client. Technicalities must be projected because on a technical ground, try to defeat. This is what you are saying. The forest department, they are answerable. Notice, I am safe. I can't
Page
answer.
number
anything.
39 last set.
And if they have not made the forest department as a party, writ petition should fail.
But they have made members. Only the reason which has been given, it specifically states that the recruitment process in some of the base level has been completed.
That is what you have done. But the question is that what you have done is not a concern.
Yes, my lord.
The question is, can you continue in re-engaging them? Question is here. Minus payment, minus pension.
You can take instructions, my lords.
The instructions you have given, you are arguing, that means you have.
This is what is on record, my lords. This is of 2024.
Sorry,
My lords, what has been.
this question is very simple.
Yes, my lords.
It's a question of law. Can you proceed by re-engaging a person infinite beyond 65?
If
It is a duty of the government when you enacted the law in a service of jurisprudence. You have already said that the recruitment process should be initiated not only to fill up the existing vacancies, but also anticipated vacancies. Anticipated means you are aware that somebody is going to retire on a particular date. There is nothing certain in the life except the date of retirement, which is certain.
one opportunity.
Or only in a more orthodox manner, I may say, nothing certain in life than the death. A person has to depart from it. The uncertainty is the date, but in service, certainty of date is correct. So, what you do, you should have
Then this, it's one opportunity to take instruction, what are happening in departments, because this is a particular corporation which has been there because the dearth of regular employees, they have.
This is not a case of that in this department only there are engagements beyond 65 years. There are other departments also these things are going on.
Sir, we have come across even a single bench has cleared many provisions as ultra vires. Chair. I just wanted to look at the prayer of the public. Nothing more to say.
The annex are not there.
The committee and enmity of the
Next.
Item number 4.
Yes.
Which was being the successful bidder. And accordingly, an agreement was signed between.
Still, you are unsuccessful. Despite you are a successful
Yes,
bidder, still facing unsuccessful result.
One. And I have operated the quarry, sand quarry, which is relating to sand quarry. Now operating the sand quarry for 1 year. After 1 year, they have not supplied the Y formula.
What they have not supplied?
Y formula.
Why for?
And for that reason, I was not able to lift sand from the quarry man. And time and again, I have approached the Tahsildar to supply the Y formula. But
Is
they,
it a Tahsildar now or
no, now, I am coming back. Thereafter, the land quarry was shifted to mining man. So, mining department,
oh, that is I know,
No.
any amendment.
mining department,
Now mining officer.
mining officer. Mining officer, I have approached the mining officer several times. But lastly, he has asked me a notice, show cause notice, under annexure 4, page 38 manner. A show cause notice to his personal hearing regarding your Usmi sand quarry under the Confederate proceedment. I have appeared. But till that, neither they are giving the Y form, not taking any decision. And I am, for the last 3 years, my lord,
I have to take instructions in this matter.
You take instruction, but this time we will be very strict in this. He has applied for Y form and he did not get it. He applied to the mining officer, he did not do. You raise these show cause notice issued. He gave a reply, yet you are sitting tight over the matter, not taking any decision. What he will do is supposed to do with a normal citizen, an ordinary citizen of the country. How his right can be put in jeopardy in this by this action.
With this show cause
You
notice.
take, you have to take a decision. If you have issued a show cause,
Yes, my lord.
he has given a reply, either the reply is satisfactory or unsatisfactory, given
Yes, my lord.
so that he will go for a next course of action. He will decide what to do and what not to do.
In this process,
Yes, that is my.
And you will impose the entire period if you could not for the entire period when you have not permitted him to live.
the next case would be.
Now I believe that though I'm of the view that the court should not rewrite the contract for the parties or do something. But these are the instances which really compel me to think and ponder upon whether the court should extend the period for query. Which my view is they should not, but still because of these special and peculiar facts which is coming. How this case will be done? 1 week. 1 week.
Item number 5.
Take instruction.
May I please report?
Next week.
20th.
Okay.
Item number 5.
May I please report? Related to unblocking of portal registrations to prevent a participating in tender. Because here is a case, my lord, the police have OP number 3 and 4 invited tender. So I am a B class, upgraded A class. I submitted B class license. The tender committee found that I submitted a false license. So he rejected, blocked my portal registration. I came before Lords. Thereafter, the tender committee, who is the tender authority, they found that it is a inadvertent mistake. They recommended the recommending authority to unblock him. They recommend the committee, unblock committee, again remanded it to follow due procedure. Thereafter, again it was recommended. But once it is recommended, the same day.
So when you applied as a B class contractor,
Now we have been upgraded to A class contract.
No, at the time of bidding, I was A class, upgraded. It is his say.
Taking in when the opening of the bid or the submission of the bid.
At the time of before tender, I was A class.
Okay.
So the tender committee or police house recommended. A proceeding was en bloc committee was
Was
held.
it restricted to B
No,
class
no,
contractor
no.
or A class contractor?
No, no, Miller. The en
There's
blocking
no
is not.
categorization that
No.
who can apply or who cannot apply.
Yes, sir. So, regarding en blocking, there is no criteria for A or B special. So, Miller, the committee was held that on a en blocking proceeding, if application 23 days, they unblock it. But my application was 84 days as per the guideline, minimum period 180 days. But my tender condition provides 90 days. At the time of taking decision, it was 90 days. And similar in the same proceeding under annexure 1, serial number 1, I am serial number 2, serial number 1, in 23 days they unblock your also. Can you have annexure 1? So this page, Miller, page 26 here also.
Yes.
Your lordship, the serial number 1 is just super class contractor. Your lordship, the second column, your lordship, date of blocking is 15th September 2025. Your lordship.
Yeah.
Your lordship, last column they have a last decision of the committee. Your lordship.
26/9.
26/9. They of the vile letter dated of wax approved the enclave of the access e-portal and withdrawal of
is 810.
810. The with effect from the withdrawn from 1810. Your lordship. My application, your lordship, next page. Can you?
Yes.
Page 27, your lordships. And the second column, the block on 4/7/2025. Lord, my portal, second column, Lord, my portal was blocked 4th July 2025.
But yet not.
But they have rejected the last line, they said that the after the stipulated period of 180 days, Lord. I again for recommendation, Lord. Your lordship, last line column, they say that hence the committee advised the Odisha State Police Housing Welfare Corporation examination to re-examine the merit of the case, keeping in view of the documentary evidence and relevant government rules, codal provision, and in case found merit in the case, even after review, then the chief engineer is to be recommended to special
That is
committee.
true. That was a letter. This was letter issued when.
The recommendation, your lordship.
This is the line, your last line.
Your
You
lordship.
simply say that you should revisit and reconsider
You advise.
for unblocking the portal registration after the stipulated period of 180
80 days, Lord. Lord, my humble submission of your lordships. The recommended blocking of the portal registration committee has no power to go to the merit. The tender committee who recommended found it is an inadvertent mistake. That is annexure 11. One in same proceeding, one they have within 23 they unblock.
And that was done that was blocking was done on 4/7.
4/7.
And then when the tender committee said unblocking.
The annexure 11 they found, your lordships. Annexure 11 and 12, your lordship. Page 132, your lordships.
132.
32. Lord, the Lord, I am permitted.
And the date
Lord, date is Lord 9/9/2025.
9/9/2025.
Your lordship.
So it was within 180 days.
Is within 180 days, Lord.
Thereafter, they did not do anything.
The committee thereafter, Lord, again recommendation was made next page, annexure 12, your lordship.
11/9.
11/9, your lordship. There subsequently the committee of the state authority, annexure 14, some clarification was directed from the my tendering authority, Police Housing Corporation. Then, your lordship, another recommendation was made 15 September 2025.
When
Lord, that is annexure 15, page 138. 138.
that was 25/9.
25/9. So, Lord, my humble
Not within 180 days.
no, Lord, my humble submission, your lordships. My tender condition provides 90 days.
True. That took the 3 months.
Yes,
That took 3 months.
yes, Lord.
Practically, if you 90 days means 3 months.
Yes, your lordship.
So if we go by a 4/7, then you can conservatively go up to 3rd of October.
Your lordships.
So it was all within the time of 90 days
Yes,
also.
yes, your lordship.
So, but they did not unblock it.
They did not, no, they did not unblock. Lord, my humble submission, the 23rd, if this 180 days is mandatory, is applicable to all. When there is a, from the said proceeding, they on 23 days they unblock one, which was
Oh, they say that it cannot be unblocked before 180 days.
180 days.
Oh.
They have
That was something of outer level.
despite of and your lordship, the merit he cannot go and once the evaluation committee found that it is in.
Oh, understand. Why you are repeating? So you got your point.
Wait, sorry.
My lord,
It's a apparent case of a discrimination.
my lord, the initial show cause
Please.
notice is issued to the petitioner. Therein it was categorically mentioned that the unblocking will be.
Sir, his tender was put at fault or was really, I would say, thrown out of the zone of consideration because the tender committee perceived that it is a forged or false certificate, he says. Subsequently, he clarified before the tender committee realized this mistake that it cannot be a false or fabricated document. And then say, no, recommending that you should unblock. In one contract, you unblock for 3 days, twice the recommendation is there. And in this case, you say that maximum period is 180, it cannot be unblocked before 180, I will not. How you have treated it, but within 23 days.
In the second column, the works department only had recommended for the unblocking, my lords. Here, my lords, the
I do
committee.
not say you have taken a shelter of 180 days.
Yes, my lord. That is-
Can you, when he is demonstrating that in other cases you have unblocked within 23 days,
Yes, my lords, as per the.
within that 180 days, then how you can treat him differently?
My lords, my twofold answer, my lords. First, the initial show cause notice is issued to the petitioner at Annex 7, my lords.
Ultimately, who has issued the show cause? The tender committee.
Yes, my lord.
They have decided that our show cause is wrong. They rectified their own mistake and then recommended, no, please unblock his.
No, my lord, there is no mistake admission, my lords. Here, initially, he had given an affidavit that he had given all the documents which are true, but admittedly, he had given a wrong document. My lords, that.
There is a distinction between a wrong document and a document or a false or fabricated document.
My lord,
Wrong document, it is not relevant for the purpose, I can understand, but false and fabricated,
my lords,
that was the allegation against him.
And it's in the reply to the showcase, he has said because of the family element in his family, he had submitted wrong document, my lords. And that was
But
considered by.
your department did not, you logged it on 4/7
Yes, my lords.
on a recommendation received from chief engineer that he has furnished the false or fabricated information. Come to page 27.
Yes, my lords.
And then the same authority says, no, it is wrong.
No, my lords.
I accept my mistake. And then why the recommendation was done?
My lords, if I may,
What was the reason of giving the recommendation?
page number 138, my lords.
To unblock?
My lords, page 138.
Yes.
The technical committee observed that Shri Rakesh so-and-so has submitted the B class registration certificate unknowingly instead of A class during going through a tough period of life and continuation of blocking period.
Whatever they have decided, this is what he says is that yes, I have given a certificate as a B class contractor. Though my status has been elevated as a A class contractor. And there is no categorization in the tender that only the B class contractor can apply. A class contractors are prevented from application. If that is not a condition put there, this document is irrelevant.
Well, because the affidavit which he has given saying that all documents are true and correct.
No, that document is also true that I am a B class. Now I am elevated as an A class.
Oh, my lords, at the time of submission of the bid, he was already a A class contractor. My lords.
So what? How it materially affect his right to participation.
And the affidavit to that effect.
The
has to be
unblocking
correct as
commit
per
cannot
the-
go there.
Sir, the affidavit must be, the material facts which he should affirm on affidavit must be of such magnanimity that had it disclosed otherwise, he would have been deprived or debarred. Every information cannot.
My lords, if I may refer to the Shokers.
Suppose he says that I am a married person
but it appears that he has already a divorcee, which has no nexus, no connection with the. I've said this one. What is this? Then how you will say false information?
If that has been what has been.
Sorry.
My lords, here the committee is the final authority, my lord, to unblock, my lords. My lords,
It is really
my lords, one provision, my lords.
unfortunate that
May I please go? Yes. Having emerged successful in the tender, he has again been
treated unsuccessful.
unsuccessful on the premises that of poor past performances. Your Lordship had the occasion to deal with the very same petitioner's case in another tender matter.
Mr. Muganti, we don't remember. I must be very candid. When I was on that side of the room, I used to remember one name
Yes, sir.
for obvious reasons. One name must be remembered by all the lawyers. Because the expectation from him is something different.
Yes.
So we know the name. After my departure from there, no namesake, only the principles I remember.
Your Lordship sees the name of the petitioner there, who's the very same petitioner. He was disqualified in that tender on the very same premises, past poor performance, and your Lordship had the occasion to go through the records to find that in fact he had completed each and every work that had been assigned to him and had been pleased to make this order, granting them opportunity to file a reply. So, my lords, this is on similar premises. I can take your Lordship through the record.
What has happened? This was,
No, this is a different matter. This is a different matter.
Time has not come.
Not
This
come.
is
This is a
directed to be listed on 27th November.
Yes, ma'am. Here, my lords, your Lordships will find that I was found to be qualified. I was participated. My name was recommended by them. Annexure 7,
Yes.
page 215. Thereafter, since nothing happened, I requested for a LOA, letter of acceptance at Annexure 8, page 218.
Yeah.
Now, my lords, thereafter, Annexure 10, they say it is cancelled and the reasons are assigned to the next page, that tender documents along with concerned papers received with your letter and the reference were returned, as they have found that poor, unsatisfactory performance in the past. That is at page 224.
Oh, that is the reason for cancellation of the tender.
Yes, my lords.
How many tenders were successful? You were L1 or H1, whatever.
I was, in fact, there were similar rates quoted by different contractors. Thereafter, I
Lucky
was
one.
successful in
I
account.
can say you are lucky one too.
Yes,
Lucky,
yes,
Lucky
yes.
one. Somebody was lucky too.
Lucky too.
No. Is there any question of lucky two? No.
No, in fact,
Only one.
only one.
The agreement has not been executed with the L1, and it is a settled principle of law till the time the agreement is entered with the petitioner. There is no vested right with the petitioner, my lords. And also clause
Very,
20.
very, very aptly put the abstract proposition of law. But there are a catch.
That's the full bench of this honorable court has.
Supreme Court has also.
Yes, my lords, the
So
series.
there is a catch. If you wrap the tender process without saying anything, then whatever be the reason you have decided. But if you tender the process by putting a stigma on him, then you'll have to what else? When you say that is a poor performance, there's a stigma which is put, and this would remain in record for all time to come. In future contract or a tender, that would be projected. How can you do it? The law does not know. If you castigate any contractor, then you must give an opportunity. If it is a simplicity of cancellation, I can understand.
Just to that effect, I do understand that, my lords.
No.
Once reason has been
No,
given.
this cannot be. You cannot castigate him in this. And the second is, suppose if he is, there were other tenders, you could have gone for a lottery. Choose any one of them, again, amongst them, not barring him. What are the decision of those Supreme Court you just gave me, that the cancellation also?
That's both your Lordship has delivered a judgment in the case of.
I know, that's why I'm saying.
Yes, ma'am. Page 27. Yes, madam.
Thus, is to see when they are running after or chasing after.
Yes,
Chasing after a particular petitioner to
absolutely,
brand him.
absolutely.
This way. The same allegation.
Same allegation way back in 2016 was quashed by the Your Lordship, and again it has started resurfacing.
You are not a blue-eyed person.
Fact remains that I am one of those persons who has been contributing tremendously to the state, which is reflective from Annexure 1 and 2, which shows the number of projects that have successfully completed to their satisfaction.
You cannot say anything.
Then we would be entering into a realm.
It's upon one person to another.
Well, in that case, we would be entering into a realm.
Yes, madam, sorry, we come.
No, 30. Yes, minutes. I have like 5 or 2 that one. Last but 4 lines.
Yes, most the opportunity should be given to you, not like.
And an opportunity to file and counter in this affidavit because what is decided in the technical committee meeting, that opportunity will be granted to me to file an offer.
That is reflected, can you change the entire scenario?
One opportunity to file a counter affidavit matter. The matter may be tagged with this matter.
Well, if in case they choose to file a counter, then your lordship has to stay the term, because today I'm filing an affidavit which says that they have now re-tendered this one.
How can you? How can you? Yes.
Now let's let me take instructions on this affidavit. This is just served right now, my lords.
Enclose the document.
We
They
will,
cannot
we will
be
write, if the tender is not noted, says noted, if not, no difficulty, not to float. Floated, stay your hand. For the situation. Is floated, stay your hand, if not floated,
Yes,
don't float.
Parasis of this. If corporation is we approve, then we protect him. Yes.
That is a two basic fundamental principles of law, not in the authority. That was clear. That is. Your money. Why are you withholding it?
And the allegation made here in the writ petition is that no work order was issued to the petitioner after execution of the lease deed, my lords.
Oh,
As per the lease deed, within 3 months, he has to commence the operation, my lords.
yes, that never want. You do a work order, how can you comment on it?
It's upon.
I will retire before. That
Let's-
the moment you will not wait for any work order to be. You will start the work. You will immediately start the work. Let us.
That is why my submission was that to that effect, my lords have to take instructions whether work order is a necessary document as per the rules, what I have read, my lords.
It is what is the, I will have no difficulty. Just imagine the impact of it. We'll record your submissions and we will go by that. And the authorities thereafter will not take a single instances where that you can't start the work without the work order being issued.
Yes, to that effect, I could not get it.
Yes, they can, of course, but moment also can come to page 39. Because page 39. The mining officer has already written to the those there is no refund process has started, but that has been halted. Plus, that is handed over.
No, that is a refund of the deposits.
Yes.
I'm not realizing that the state is a formidable opponent.
Yes.
Or the opposition has come.
And he has been opposite since long,
Yes, that's there.
as in that capacity.
Item number 8.
I mean, permitted to withdraw this restriction. As per opposite party number 4 has already been withdrawn his bid from the tender process.
Item 9. Right.
Excuse me. Similar case to the one that was already heard by your lordships. IOCL, this is similar matter to what the matter that your lordship had heard, that IOCL matter was we had to replace the 2 tankers with higher.
Oh, yes, yes, yes.
Say exactly same, there were 3.
We have delivered, I think.
Fine, the other one was passing on the order. No, order has
We have
been.
delivered, I believe.
Lordship has not probably. Who communication, yeah, probably not sure.
It has
not
been done. I believe so. I believe so. We have done.
Probably.
Both of us are there, the other matter.
It has not been delivered.
Probably delivery is.
My gut feeling says that have dictated.
Lordship has dictated from
The pilot number advances that new vehicle.
we have replaced it, it's there.
Higher capacity.
Exactly.
That is-
Same, it's exactly the same. No, it's the same case.
I may be wrong.
Pending.
What is the number?
I am.
I passed on the number, I passed on the order. Last order.
But it's not the same case. It's different.
5005.
Today's matter is different.
No, he's saying the same matter.
No, same IOC.
Principle is same, but
Principle is same.
parties are different.
Parties are different. The point is same.
It's not approved.
They-
Are you appealing for IOC?
But no, I'm appealing for the same petitioner.
Maybe my misconception.
No, this is the matter which your lordship has heard.
Yes, ma'am. I
This is the matter which your lordship has heard.
Yes.
I remember.
This is the matter. I passed on that number, your lordship has heard that. In fact, major portion of the order was dictated also.
Lordship said that in the court that major person.
Major portion order has been dictated.
That's why you see.
Lordship will call it tomorrow, so that
This matter. No. Look, this matter. I'm sorry, we apologize for that. But this matter, in fact, what my learned friend will say is little different. But we should not pressurize your lordship, not at all. Your lordship should be allowed to play in your lordship's own joint, that's all. Because our. But today's matter, I am in bare need of an interim protection. The second matter, if lordship. That happens. What happened, in fact, in a while, I'll tell you. I came with a file to argue a matter. I did not open the file, but argue a matter which was already argued in another matter, some other fact, went on placing before your this honorable court, which was not that fact of that case which was listed or sometimes that happens. But here before your lordship, we sometimes get confused with the facts and argue another matter.
Yeah. Actually, this matter, just to refresh your lordship's memory, my lords, your lordship had dictated major order in court.
It is, they have not extended.
That is what I really want. By virtue of an order of the court, it was directed to be accepted.
And against,
Yes, sir.
but against all the orders passed by the Honorable Court on 20th and 26th, against all the orders, we have preferred appeal.
Yes. We are considered for a proposal for, does not mean that they have, they will be promoted. The right to promotional vote is not a restriction.
Yes.
But the consideration therefore definitely is a right. And the consideration is not suitable. But it is suitable, you decide. Our is not approach, that is what I want to use.
But had it been a case, my lord, they were never given opportunity, then matter is different. But on 3 occasions, categorically, it was.
Now, I found was some issue. There was, I would say, disagreement. Whether there was a technical glitch in uploading. There appears. So they say that there is a technical glitch. I'm giving you a physical copy of an application. That also allows or sometimes implies that yes, they are unable to go uploading on a OTP. So they have given up. In that scenario, I think you are a modernist lawyer.
Well, even then also the government was generous to grant them extensions. But that is what I am saying, my lord. But yes.
What is the income and what you do? When the court became a extended and directed to accept. It is there, in fact, it is not going to be about the passive already. It is not going to get the rights of the person who have already been promoted. You have not undertaken the exercise, I believe so.
Well, already promotions to 400 persons.
Already done.
Yes, my lord, this is the promotion.
When prior to the week or after the.
But it's on 10/10/2025. That is after this. On 8/10 was the CSB and
So are they looking at one of the, or they have been left out?
but they don't fulfill the criteria of the government servant conduct rule, because that there the rule says it is a prerequisite for submission of.
Sir, again, I'm saying, sir, after this order is passed, where the court has directed you to accept that particular property details.
Yes.
That means the compliance has to be ensured. And thereafter we consider, if you do not consider that and you do it, that means, I do not want to make any observation. This order is still going, the steady measure of this. And you have done it after this order. You should be strict in this regard, no doubt. What you change?
It's all the persons, including these 400%, including the petitioners, millets, all of them were given equal opportunity. They could able to submit their. But these.
But what the court has directed, what was the situation which prompted you to act in this?
Because of the vacancies, my lord.
I understand. When you.
It's a disciplined force, my lord.
Staying at your place. Either you could have challenged immediately and stop that particular process. You should stop that particular process and invite the other court to interfere with your. But why you proceeded in anticipation that the High Court complaint court will interfere? The court will dismiss all your appeals. And direct you to implement. What would be the position? To those 400 people with whom you are. position would have been different if it is already done prior to the writ or the prior to the order. I can understand. The right is it as already been.
Sir,
After the order is passed, you know that they are to be considered. I think that's the direction also. Are you not in contempt?
but the court has only directed to consider their property statements, to accept their property statements. So promotion.
That means so far as that the impunity which was attached to them is not following that particular mandate or the statutory requirement. That is gone. If the order is to accept, that means the compliance is ensured. You cannot say the basic. You can't say that they have not followed the mandate of the hospital. If you can explain, the board is directly to expect. The last chance.
The court, subject to my lord's kind acceptance, court has proceeded on the basis of the statement made by the land council for the petitioner that today is the last date and we have submitted, which is incorrect and contrary.
Why? Yes, I'm asked. You are targeting in the month of October.
On 8th of October, the selection board was there on
20th of September and 26th of September. If I correctly remember.
Yes, my lord.
So this is how you were aware that this order is essentially.
My lord, under the rules, my lord, yes, that is at page. So lordship may kindly have a glance to annexure 8, page 55. And yes, my lord. Conduct rules, if your lordship may kindly see 4, page 56. Rule 4. May I take your lordships to the last lines? An employee making a declaration found to be materially incomplete, misleading and false shall be liable for disciplinary action in major penalty. Proceeding under the provisions of the respective discipline. Besides, next page, my lord, besides up-to-date filing of property return will be a prerequisite for promotion.
I understand. There is no difficulty. But you see, I take it. But there. Significant amount of that. What a procedure matter of. Matter of. Maybe that's the knowledge, yeah, requires your age.
But this amendment. That is at page.
In my lord, counsel from police.
May it please, my lord. My lord, this is a very short matter. While releasing the vehicles, the court has said you pay half the insured value, whereas Rule 4, Sub-Rule 2 of the PMLA taking of possession rules, if I can just place that rule, my lord, my learned friend is having a copy, says the equivalent value in FD has to be given. If the attached property is of a nature which is likely to decay, which is likely to perish, then the person from whom it is seized or attached can get it released by paying the equivalent value in FD. Instead of that, the learned single judge has said,
It is not a perishable goods.
it may not be. That is, I'm not even, I'm for a second, I'm not even going on that, my lord. Even assuming, my lord, the learned single judge was right in saying that it has to be released, then the equivalent value, it could not have been half of the value, my lord, is my submission. Please see the relevant rule, my lord. My lord,
Was it considered by the single bench?
not even considered, my lord. Not considered at all. My lord, may I have
Yes.
Rule 4 of these taking possession of attached property rules, Sub-Rule 2, Proviso, where the attached property confirmed by the adjudicating authority is liable to speedy and natural decay, or the expense of maintenance is likely to exceed its value, the authorized officer shall sell such property with leave of the concerned special court or adjudicating authority as the case may be, and deposit the sale proceeds in the nearest government treasury. Please have the proviso. Provided that where the owner of the property furnishes the fixed deposit, receipt of a nationalized bank equivalent to the value of the property, in the name of Director of Enforcement, authorized officer may accept and retain such FD receipt as security and send a report to the special court or adjudicating authority as the case may be for information and appropriate action. Now, please see, my lord, even though against this very confirmation order, the appellant, the writ petitioner before the single judge had availed the remedy of a appellate tribunal, it parallelly pursues this remedy. And please have the operative part, my lord, impugned order at page 66.
Yes.
The operative part, my lord, will find at page 672. It starts at 66, para 12. And we are aggrieved, specifically aggrieved. Ideally, my lord, since the petitioner had approached the appellate tribunal, he could have made all.
What is this? It's a vehicle. It's a vehicle.
These are several vehicles, my lord. And the release has been directed on payment of half the value, insured value. My lord, may see para 12 at page 72. In such circumstances, the scales of inquiry, equity, must tilt in favor of the petitioner. The ends of justice would be met if the interest of opposite parties is secured while simultaneously protecting the property from damage. Accordingly, in the peculiar facts and circumstances of the case at hand, it is directed that the vehicle seized from the petitioner.
Why not, sir? Second proviso to sub-rule 2 of rule 4 apply here.
Yes, my lord.
Provided
that is a mode of conveyance of any after obtaining its valuation report from the motor licensee or any other, as the case may accept and
the motor licensing authority.
Yes, I bow down to that, but it could not have been, my lord, half the value of the insured property at all.
I do not know whether he has asked for a valuation report.
No, it is only done on the basis of the insured value. My lord is absolutely right. In fact, I'm the further proviso would be a more apt application, my lord, of the rule, relevant rule to these vehicle. But please see para 12 of the impugned judgment. Gives complete go by.
I understand. That is what I am asking, sir. If it is, yes. Because I find that sub-rule 2 really I would say the
I bow down.
enabling provision talks simply of a sale.
Yes.
With the leave of the court.
That's right, my lord.
Proviso says that if the owner furnishes the fixed deposit, the value, then it can be released in its favor.
Correct.
Proviso also says that if he furnishes, if the evaluation report comes and it says that this is what is there, then he can furnish it and then get it.
Yes, so therefore my submission is this for the second proviso, as my lord has rightly pointed out, would be more appropriate provision, and the report from the concerned authority may be called for valuation report. Evaluation may be done, and
How can it be done, sir? Half of the valuation can be done.
Cannot only one thing that 100% value. I have to pick few words. If also we not convinced, then I'll furnish the rest 50% value. It is IDB value. It's not the IDB value. IDB
What-
value of the insurance company is IDB value. That is more.
What is this IDV?
What is the full form? Insured amount IDB value.
Insured.
insurance, it is the latest, as per the latest insured value.
Paid by the insurance company.
I had depreciated, it should be a depreciated price.
Yes.
Yes, my lord.
Because the income tax, I think, I do not know about the car.
Yeah.
The 30% or somewhat depreciation every year is permissible.
WDV.
20%.
IDB.
Written down value,
Ah.
balance in corporate companies are just.
That is
That is written down value in
That is
that.
IDB value. If let us suppose
Asset.
the vehicle is completely damaged, then IDB value, the owner will be entitled to get IDB value.
IDV stands for insured.
That is, well, Mr. Counsel, that is so far as the insurance vis-a-vis the claimant is concerned.
That's right.
Insurance liability is up to the extent of that amount.
Yes.
It will not exceed beyond that. Sometimes it so happened that the experience goes that even a claimant can reduce the amount of insurance just to avoid the payment of the premium. He
Yes,
says that I will be happy if my property is insured to the value of 5 lakhs,
yes, my lord.
though the vehicle may be more valued. But it's a vis-a-vis the claimant, insurer and the insuree. Nothing more than that. It doesn't reflect.
Absolutely, my
that.
lord. Absolutely.
Declared value.
Let there be an independent valuation, my lord, is
So
my
it's the insurance part is different than the actual part. So you'll have to, this proviso, second proviso is
Ballot
very apt.
only limited aspect, man. Limited aspect I'll submit ballot if you not to limited aspect. Ballot the case is that as per the ED statute ballot, I received the person received 98 crore from for execution of work. There is a contract between the petitioner and the company, defaulting company, against whom the main accused, against whom ED has proceeded regarding some loan aspect and all that. So out of that 98 crore, my lord, that is for execution of the contract, supply of iron ore and manganese ore. So that out of that 98 crore, since contract couldn't be, I spent amount for execution of the contract, because as per our contract, I could have entered into contract only with the other company, not with the outsider. That was the terms of the contract. So I deposited, whatever I'm saying is based on record, my lord. I deposited 26 crore before the government for conversion of forest land, and also spent 26 crore for extraction of the iron ore. So, and also I with the contract couldn't execute, I also returned back from 38 crore amount. That is, it is the available from it is record, and state crime branch has also in the, done an investigation, and state crime branch has also stated so in the charge sheet, and charge sheet crime branch said that we have not committed any offence. So they charge sheet submitted.
But after all, that is, I understand that's a merit. That's the merit that you will be
I'm not on that.
exonerated. Now, question is the release of the vehicle.
For the purpose of value, sir.
Absolutely. Now, once it is, the mechanism has been provided, then in that event, how can a court overlook the provision of the statute?
That only my submission is that they have got much more than the 100% security. That much more.
That is not the, because it's a release.
I have not
It's a release.
other matters, my lord.
Mr. Counsel, I appreciate every bit of your argument. That sounds logical, no doubt about it. But we can't go beyond the statutory provisions. If the specific provision or a specific rule for taking possession and the release is already provided, Then one has to, because it is not the money is going to them.
Yes.
It is a fixed deposit which should be placed with them.
Place with them and.
That in the event,
That's right, my lord.
if
Subject
something
to-
happens, then they will definitely
Subject to outcome.
themselves
Releasing
from
that-
realization thereof. Nothing more than that.
Interest also because if the.
You will continue getting our interest.
Vehicle's valuation will go down. So by the time it is, if it's not released, then day by day valuation will go down.
Because the difficulty is that once the vehicle is released, then it comes to your disposal.
Yes.
Once it comes to your disposal,
Yes.
then your right to deal with the property is also, I do not find any fetter here. That any fetter can be put to a right to use or right to deal with the property. So that can be dealt with by you.
They also kindly say system, they have paid the direct investment of fund is security equivalent to 100% of the ID value. Because
Correct.
ID value is always higher than this. They have paid for it.
No.
They have paid for it.
No. Where they have paid?
61 value.
Show us that they have
Read
said.
it, yes.
Right?
Read it, page 61. They have paid for it.
That is the second prayer. That is my learned friend is right. That's the second prayer. my lord.
Yes. Where?
Page 61.
Yes.
It should at least be this, my lord, is what is
Oh.
Actually, it is always higher pilot. That is the reason why probably they have said so. If lordship will convey, they will be.
No, then in that event, we will not go into any other aspect. We will take this particular value as the value, and then you deposit the 100% as
Fair
per the law.
Fair enough. My only other request is, my lord, the writ petition was filed on 22nd September. The matter was taken up on the 25th September without even calling for a reply on the matter. Certain observations have been made. If my lord will only see page 7, para 9.
Sir,
My difficulty is the
no,
appeal.
sir, no difficulty. Sir, it is you who was the writ petitioner.
Not me.
No, it is
the present petition.
My learned friend was the writ petitioner. My lord, I am appearing
No,
for the
then
ED.
this prayer is by whom?
The prayer is in the LPA, my lord.
In the writ appeal?
Yes.
Okay, I got it.
My lord, my only request is that any observation in the impugned judgment should not prejudice the appendency of the appeal before the appellate tribunal, my lord, because my lord knows
That is on a different score. We will simply record. You will come, I will dictate.
my lord, there are some
We are simply modifying the order of under is there, and we will saying that the spirit of these provisions are the 100%. So we will give you a 2 weeks time to put in the further fixed deposits, covering that amount with them.
my lord, the observations in para 9 and para 10.
There's nothing. We will say that nothing will sway the minds because the consideration is limited to this extent.
Fair enough.
Release.
That'll
Right.
deeply obliged, my lord.
Oh, yes, we have noticed. 95% done. But I do not know for what reason it was there. It was not placed. I will correct it today. Don't worry. And that will be delivered tomorrow.
But with today's two matters, item number 9.
I'm keeping it this tomorrow. Don't worry.
That's fine. Great.
Item number 15.
Oh, I have not dictated. I will dictate. I think 15. You will. So you, Johnny, What is? Who?
You want adjournment? The signal is not there.
But
The
I have,
correspondent. The correspondent.
Which respondent? There are 23 respondents. Yes? 7 to 2. 7 to 23. Yes, and the state is there. He is representing 1 to 6.
No, it's 1 to 6 minutes. 1 to 6.
Who is your senior? What has happened? Where he has gone? Oh,
professional one. So he,
that's a professional.
election, I have urgency, let's see, because
You are subconscious.
I'm the, you say return candidate, I'm there, sitting.
What your writ petition is dismissed or allowed?
Dismissed, let's.
No confidence against the.
Yes, let's. No confidence in contract to the entire statutory provisions, let's see.
No confidence was allowed.
Allowed.
And then you challenge that decision.
Decision.
And the writ petition is dismissed.
Dismissed, let's see.
On what ground?
Plus ground, in fact, let's see, mine, I had taken ground non-compliance of the any provision of the law,
Okay.
but honorable single.
Madam, when he will be available? He has to be available tomorrow? No? Then? Monday? First matter?
Some protection, let's see, otherwise it.
Nothing is going to happen.
Let's see,
When the order was passed.
let's see, order passed, let's see, that on 13/10/25.
So you have waited for more than 1 month. Can't you wait for 3 days? What are you talking about? Urgency suddenly?
Corresponding.
No.
Immediately I have approached, let's see.
Whatever, but you waited 1 month. 1 month has already, now today is
Let's see, if they will count, let's see, law says, let's see.
whatever I understand, sir, today can't be so unreasonable. I know you
No, let's back.
can't be so unreasonable. If you can wait for 1 month, wait for 3 days.
What I say, let's see.
3 days.
Let's see, let.
Monday, first matter.
Let's see, first matter. Government should, let's see, should not come up with any adverse order, let's see, only, because that is up to them. If they will publish, then it will be infructuous.
Then 2 days time.
No.
If my lord is
If they notify, it will be infructuous, let's see, let them not notify.
They have not notified for such a long time. What do you think?
Let's see, if they.
Suddenly.
If tomorrow they notify, then it will be infructuous. Not that
Whatever. They have not notified for 1 month, sir. Every day was causing you a problem.
My friend will communicate, that will suffice.
No,
And if we taken up on Monday, that
Not
suffices.
this indication is sufficient.
Let's see,
That's all.
grateful, let's see.
Monday.
Item 16.
First case, let's see.
Yes.
Plus, grateful, let's see. Grateful.
Yeah, it's for the cavitator in this case. I'm such a cavitator in this case. Let them serve a copy and let this matter be called next week so that I can.
Actually, 16th is the date of examination.
Why you did not, your advocate in the court, when the caveat,
You respect.
it is endorsed that the caveat is there.
He had already offered what he said.
I contacted my learned senior yesterday. I even called today morning 10, 11, my lord. I didn't find any response.
My lord, he contacted.
He did not picked up a phone.
No, my lord. I went to my senior's office yesterday.
Yes.
Then I could not serve the copy because he was not present. He said,
So somebody else must be there in the office.
No,
No.
My lord, I am told that he telling.
Today, sir, tomorrow let the matter be taken.
My lord,
Sir, I saw today.
Yes, let it be called as the second case on Monday. Your lordship will.
Monday, we are appearing for the interview because I have personal difficulties on Monday.
Tomorrow.
I saw just now.
Give him. Immediately tell your junior to give him.
Yes.
17th.
You have served copies in the court. You have served copies.
Yes.
Hello.
17.
The petition for eviction of unauthorized occupant from government land.
You are the unauthorized occupant in the government land.
I am not.
So?
I am petitioner. I am filing PI.
Yes, for what?
On the last occasion,
Not on the last occasion, I had mentioned to my lord that eviction had been scheduled to 28th of October. In the meantime, Lord, the enclosure, they have come up with a writ petition that they have obtained a stay order, and have passed on that order.
there are more than 100 enclosures, but some of the
It is others, we don't know how many. Is a Niranjan Das and others. How many? It may be 100, it may be 200.
not suppressing the filing of this.
Go to that page. Go past the interim order. Let's take down.
This matter is identical to that order which we have passed, taking note of your plan, action plan. Subject as that action plan 2025 to remove all encroachers.
They are still committed.
We have incorporated in one of our, and this order also, 6/7/2024 itself. It is enclosed to this. But that was not.
No. This has been passed.
October.
By an order dated 9/10/2025. The
even asking and making necessary requisites to the superintendent of police an extra 10.
We are representing only the control board.
No, but has postponed the
Why?
I am finding the counter today.
Why? Why postponed?
That was postponed. The reason is may permit to file the report. Document annexure 4F at page 17. The reason is the auction was held in the year 15-16, but the public hearing was supposed to be held after 10 years. That is which clearly violates the environment minor rules. And clarification has been sought for from the Ministry of Mines. That is the collector is the competent authority to postpone.
Is there any deadline given in the OMMC rules that the public hearing must be done within a time frame?
No, it's not there in the OMMC rules, but there is a 2006 notification of CR's notification, which says that it has to be done within 48 days. 45 days.
What is that?
45 days.
So far,
What is this notification?
I have only one copy.
But so far, as per the notification, so far the board is concerned. But the board would be power there that it is limited to the extent of power of the board, to the extent of holding the meeting and sending the entire proceedings in the meeting to the regulatory authority, Ministry of Environment or the State Environment Impact Assessment. Board's role is limited to that extent.
Clause 7. There is a state point number 3, stage 3, public consultation. Under 7, clause 7. Under that stage 3, my lords will see point numbers 3 and 4. Stage 3 public consultation, under that points 3 and 4.
Does not talk about anything. It simply says that if it is not done within 45 days, then you will appoint another agency. What you were doing?
The CR is to appoint first member of the pollution control board is to carry out within 45 days.
They have not done. Then what is your role?
Our role, Milord, the pollution control board had requested the collector to convene to give police protection, Milord, for the meeting to be convened, and that we have not done. The collector, Milord, I had given my instruction on the last occasion. The collector said, Milord, we had asked for clarification to the department because it relates back to 10 years. But it has not been cancelled, it has been postponed till...
No, but how can you, if there is no mandate which is given, then how can you do it?
Milord, that is a fact, Milord.
So, I do not find there is any cap which is given. Then if it is not done, then it will lapse.
The reason is been given by the district administration annexure E of my counter. Let's see the annexure E of my counter.
Annexure?
Annexure E, madam. Page 70.
Page 70.
May I place it, madam? With reference to the correspondence of the subject item, it is to intimate that...
No, that is a 10-year. Such activity may attract violation of OMMC. Where?
And accordingly, that is the...
Where? I do not find there is any impediment.
We cannot postpone. Only the collector will postpone. And the meeting there...
What your collector is doing?
No, there is no such provision in the OMMC rules. That 10 years, there is nothing. But Milord, he wanted because it relates back to 10 years.
So what?
That's why he's written to the government. And he also said, Milord, I've given the instruction that it is not cancelled. The public hearing is really...
No, he can't postpone. This is how the 10 years has elapsed.
Lord, 10 years has elapsed because Lord, the petitioner could not provide the EC, Lord, the environmental clearance, and that Lord, in the rules. Rule 29 says that it is solely the responsibility of the petitioner. They have to provide the EC, obtain it from CR, and then provide that. The petitioner has defaulted. So that's how 10 years have gone by. Now, because this
No,
10
so
years-
why you did not take steps to cancel it? That if you have not, why you have not done?
Cancellation and postponement, the district administration is the competent.
Sir, these are two concepts, sir. If you cancel is a different concept. Postponement is a different concept.
No, what we said that they are the competent authority to
Sir,
postpone it or cancel it.
Sir, this SRE is also distribution. You see, it is in the month of August. You are stating that it is lapse of 10 years. Still then you are not showing any dispatch.
The district administration will require that.
August, now we are in November. The postponement has also no reason.
So this letter.
Only 10 years. And it does not find any. Yes. No, you can't postpone the hearing.
Yes, your Lord.
Within a time frame. Show us the OMMC rules.
My Lord, the OMCC rules do not contain that. Instead, the 2006 EIA assessment rules confirm that.
2016. Which rule?
My Lord, the one that my learned senior just handed over to your Lordship, the Environment Impact Assessment 2006, which speaks for public hearing. The timeline being there.
Where is that?
Lord, I've given a copy in the just.
No, this is something, another notification.
My Lord, that I think my.
It's not a rules.
My friend is referring.
Yes, ma'am. That notification contains the provisions for the public hearing.
No, under the OMMC, because he says under the OMMC rules.
The rules or notification.
My Lord can have the first page. My Lord, this is made under the notification under sub-rule 3 of Rule 5 of Environmental Protection Rules 1986 for imposing certain conditions. The very first paragraph of the preamble, my Lord.
No, you're talking about the notification dated 14 September 2006.
Indeed, your Lordship. It is.
I understand, sir. This is not a rule. Anyhow, it's a notification in exercise of the past.
Yes, sir.
To issue such. I am talking about when the postponement order is passed, it shows that it has lapsed 10 years and such activity may attract violation of OMMC. Where is the OMMC rule talks about?
Yes, my Lord, that is for them to satisfy your Lordships. In any event, your Lordship.
Why you are interfering? I'm asking the State Council.
No, sir.
Yes.
My Lord, there is no provision as such, but my lords may have a glance at Rule 29 of the rules which speaks about environmental clearance. That is a prerequisite. Rule 29, my lords. That speaks about environmental clearance.
Yes. Directing me to conduct the public hearing and something to exercise. There's no factor. Only ground is this. This is called a notification only.
My lords, that is a notification by the central government.
Pursuant to the not beyond a count, not beyond 40 days. So that at least.
Item number 20.
45 days as is.
I'm grateful, Your Lordships.
Yes,
20 minutes.
yes.
The petitioner before Lordship, technically qualified in a tender process but unable to participate in a reverse auction. And due to technical glitch, last occasion the matter was before your Lordship and opposite section number 123 instruction.
Third. My lord, on two cases we'll file the counter. And one case today we are filing, already been filed. Already filed and we'll serve the copy to my land sister. Well then, today we are filed. Already filed. Interference? All three cases we file the counter, will serve. Copy might have served in two cases, another copy will serve today itself.
No copy is served to me.
Where he
Today.
serve copy.
Serve copy today.
Yes, yes.
It is submitted by the learned DSG that the counter affidavit. Yes.
No, this issue pertains to damage caused by use of fly ash, my lord.
What?
Fly ash, my lord. The damage caused by fly ash, my lord. I'll draw Lord's attention, my lord, on annexure 9 as to how, my lord, the breach was conducted, contractual breach was by the contractor, and how this issue was raised, my lord, way back 1 month before the happening of this incident.
What is this annexure 9? I do not know annexure. Which page?
My lord, this is on page 86.
Huh?
Page 86, my lord. Before, my lord, the incident is of July, my lord, and before that, my lord, this was being pointed out by the engineer in charge to the contractor that to please curb the nuisance of this fly ash, my lord. I'll just read with Lord's permission. My lord, this is a letter of 4th June 2025.
Yes.
Para 1, my lord, the construction of embankment with fly ash around 20 kilometers is in progress, whereas no RFI has been received, conducted till date, which is clearly breach of EPC contract agreement. The reason behind non-submission of RFI may be clarified. As per EFC contract, the work which the authority engineer is entitled to examine, inspect, measure, it cover up, put up of view or any part of the work is placed, the contractor shall give notice to the authority engineer whenever any such work is ready and before it is covered up. Like fly ash are dumped in carriageway, making a trench of 1.5 to 2 meters throughout the road. The guidelines behind making trench may be clarified. The construction activity are prohibited in forest area, which are being clarified to your authorized signatory.
This is what an executive instruction or statutory instruction?
My lord, this is an my lord, administrative direction to. My lord, in fact, how to use fly ash probably, my lord, is the MOEF guidelines.
Okay.
So this eventuality, my lord, they were using fly ash in construction of road. But since they were not following the rules or something, my lord, on the intervening night of 4th and 5th of July, there was heavy rain. And my lord would see an extra 2, my lord, as to the havoc which this fly ash has caused, my lord. The photographs I had placed on record, well, I'll draw Lord's attention on page number, my lord.
Page number you give me because
Lord,
no mechanism of tagging the annexures here.
I'm so sorry, my lord. Apologies. My lord.
This is what is
page 30.
Page 30. Yes. What is this?
This is
the water body.
Water body, and my lord, my lord would see the fly ash on the water.
This is a fly ash or is a normal
Fly
water?
ash, my lord. Fly ash.
It has to be more transparent water, clear water.
This has not.
No.
No, the impact of fly ash, my lord. We
What
would
is
be
this
happy
white?
if it is transparent, my lord. We would be happy, but the problem is that this is fly ash.
Yes.
Then my lord would turn to page 34. Now it is in the field also.
Yes.
But these are all fly ash. Then my lord, 36.
34, where is the fly ash?
My lord, the white.
Lot of vegetations have been grown there. The herbs, shrubs, everything is coming out.
My lord, in fact, it is initially certainly, my lord, the herbs were there, but the fly ash at the my lord could notice at the bottom.
No, he must have taken out the mud or sludge from the water.
He is standing on that.
So it's not a
is
water.
also standing on that, my lord. Yes, I bowed down, my lord. And then my lord would see 37 also. My lord, everywhere the fly ash. Now this has an effect, my lord, which will badly affect the fertility of the land for years.
What is this going on? This will definitely destroy and damage all the cultivable land nearby, even polluting the water body.
Your Lordship had on the last occasion stated that since these falls on the Schedule 1, the NGT Act, Your Lordship, NGT.
Oh yes, I was just inquiring whether it will come under the purview or it will
Purview of
be under the NGT. Yes.
2012-8 SEC 326, Your Lordship, Bhopal Gas, that is Mahila Udyog versus Union of India.
Show me the provision of the act first that it excludes the jurisdiction.
Your Lordship, it is 38, Schedule 1, and here the Air Prevention and Control of Pollution Act 1981 and Water Prevention and Control Act 1994 both comes under the Schedule 1, Your Lordship.
No, exclusion clause I just wanted. Exclusion provision. Like many under Article 323A, you will find there are many tribunals where the exclusion clause is there. Yes, what judgment you are citing?
2012-8 SEC 326, Your Lordship, Bhopal Gas, is it Mahila Udyog Samanthan versus Union of India.
What it says?
It says that both of these are under the NGT domain, Your Lordship. Both of these are under the NGT domain, Your Lordship.
True, there is no difficulty. Whether
There I just got this case, so I think I don't have a copy of it right now, immediately before coming to court.
Yes.
2012-8 SEC 326.
Page 326. That's the Bhopal gas.
That judgment is available. I think my friend would be referring para 39 and 40 of that Bhopal Pidit Mahila.
Yes, mainly paragraph 40. Yes, paragraph 40.
My lord.
It talks about this, the High Court should not ordinarily entertain if it relates to anything which comes under Schedule 1 in
Yes.
order to avoid any conflicting decisions to operate.
My lord. Yes. My lord, two replies, my lord. Reply one, my lord, this was diluted by subsequent, my lord. In fact, with humility, my lord, and this Bhopal Pidit Mahila is by 3 judge bench. Subsequently, when my lord, the environmental bench was constituted, Justice Nijar was not in favor of this judgment. So again, my lord, an order was passed in Adarsh Cooperative, my lord. My friend will, my lord, just pass on that judgment.
My lord, may I
Where this 39 and 40 was stayed. Justice Patnaik is the only common, my lord, judge in both the judgments, my lord. Well, Adarsh Cooperative Union of India, again, my lord, in this case, a writ petition was filed in Bombay High Court, alleging violation and breach of environmental laws. Then my lord would read, my lord, with the lord's permission, my lord. The directions are co-op 40 and 41 of the Bhopal Pidit. And then last.
No, what happened ultimately?
My lord, ultimately, Justice Lokur transferred this matter to Bombay High Court. But nothing was passed on this, whether Bhopal Pidit Mahila is still binding or not.
No, they doubted, they definitely doubted this particular observation in Bhopal matter, so far as paragraph 40 is concerned.
Yes,
they definitely doubted. It says that how can it be restricted to NJT only? Why not the High Court should interfere and entertain it? But that's why I want it, because
finally,
ultimately, if it is untouched and not ultimately.
Even the power of High Court has been decided by subsequent judgment. Here, my lord, this 40 and 41 was stayed by the 3-judge bench of the Honorable Supreme Court. Then, my lord, another judgment is, my lord, Madhya Pradesh High Court Advocates Bar Association. They say the High Court's power cannot be, my lord, interfered in any manner. I'll just read one para 15. This is with my lord would see para 2, where the issue was framed. And this issue relates to, my lord, the power of the Honorable High Court, my lord. Para 2, my lord, on the next page. The issue to be considered in this petitioner whether the National Green Tribunal ousts the High Court jurisdiction under section 14 and 20 of the NGT.
True, that's the only very issue number where A is decided.
Para 15, my lord. And these issues, my lord, relate to fundamental right. So how can, lord, the
No, that is true. That's true.
Para 14 and 15, my lord. 15, I think.
This is really based upon that particular L. Chandrakumar's judgment of the judgment of the Supreme Court. I think 1997.
Yes, my lord.
Supreme Court.
Yes,
it talks about that the Article 226 and 227 comes within the purview of the basic structure theory as propagated in Keshwan and Bharti's case.
Yes,
so this cannot be abridged nor can be curtailed in any manner.
Yes,
but the very innovative, I think the decision was taken that instead of going to a single bench, let us go to the division bench. First, you move to a tribunal.
Yes, Lord.
So the question is again that if the tribunalization which has started, I think by virtue of a 42nd Amendment,
my lord,
of the Constitution, then Article 323A and 323B was introduced.
Yes, my lord.
Then in that event, it will be a first tier of filtration than approaching the High Court directly.
My lord.
So now you have approached directly.
My lord, in fact, the problem is many-fold, my lord. In fact, my friend's statement is again incorrect that the Air Act is absolutely under the jurisdiction of NGT. My lord, what has happened in this case, my lord, would see my para D in the prayer D of my my writ petition, my lord. I'm seeking some direction by the Pollution Control Board, my lord. That direction comes under 31A. Again, my lord, Supreme Court says that the powers and implementation of 31A is not within the realm of NGT. That was further decided, my lord, in Tamil Nadu case. So there has to have, my lord, a complete forum where I can go. I cannot, my lord, after sometimes file a writ petition that look for implementation of the direction of the Pollution Control Board. Now it will lie, and for the quantification purpose there will be NGD. I'll read one more judgment for my lord's consideration, my lord. The Tamil Nadu Pollution Control Board.
Yes.
All would.
What is troubling me is the doctrine of overlapping. So I'm really concerned about whether it overlaps the domain of another. Transgression of the boundaries is also one of the factor. I think the system got hanged. Is locked out. Which paragraph? Yes.
फोटो डिस्कनेक्ट कर देंगे
My lord, Tamil Nadu is para 38, my lord. My apologies, my lord, I was disconnected. Para 35 precisely, my lord, in Tamil Nadu case, my lord, where 31A and 33 had been the subject matter, whether this would also go to NGT.
No. In this case, the only point which really brought up before the Supreme Court was that whether the NGT can exercise the appellate jurisdiction or the appellate powers. Because there were certain orders which were passed by an authority, the appeal was sought to be filed before the NGT.
My lord.
Question was that how can you assume the jurisdiction and the powers of the appellate authority? You are not supposed to decide this.
My lord, I bow down, my lord, but that problem would come when
But
the issue
the question is an original jurisdiction, because the tenor of the judgment, as I could go through, the tenor of the judgment is that if you exercise the original jurisdiction, there is no difficulty. But you cannot exercise the appellate jurisdiction.
My lord, in fact, the role of the NGT is to issue direction and get this direction implemented. So 31A would come in the way when the NGT is attempting to implement.
So that is why I'm saying when the NGT is exercising the original jurisdiction.
My lord, but simultaneously,
no difficulty.
Simultaneously NGT also passes a direction for execution. Say that.
If it is NGT is not a teethless tiger. Simply it can pass the order and it cannot implement its order.
For 31A, my lord, it will be.
Yes. So if it can also implement its order.
In 31A, my lord, it cannot. With humility, my lord, 31A it cannot.
Where is the 31A?
My lord, 31A, my lord, the of Air Act, my lord. Air Act 1981, my lord. I will read it out with Lord's permission, my lord.
Where this judgment it is quoted?
My lord, 31A probably is not quoted in this judgment.
NGT Act is there, anyhow.
My lord, 31A is quoted on page 32 of this judgment, my lord. Power to give directions. The page is on the right side bottom, my lord.
This book does not contain this.
Well, NGT does not have 31A Air Act, my lord. Air Act, my lord, was quoted in the Supreme Court judgment, my lord. Tamil Nadu judgment, my lord, in page 32, my lord, that was extracted. Power to give directions.
No, this is I'm not really concerned. I was concerned with the provision of the NGT, and 31A is not originating from NGT. It says the board, if the state government may pass direction upon the board to exercise such powers and performance of the functions and issue directions. And if that power is not given, then in that event it is there. 31B talks about I think this
31A word is missing in 31B, my
Is
lord.
relation to a power of the board and the
My lord,
city government.
just one line below that, my lord. Any direction to any individual also, my lord. Just one line. On this behalf, board may in exercise of power and performance function issue any direction in writing to any person, officer or authority. Because my prayer B is to direction to them. And if this direction is given by the pollution board, then NGT is incompetent to implement that direction. For that portion, my lord, I will be, my lord, compelled to file a writ petition.
Very difficult.
My lord, we are facing this problem, my lord. In fact, my lord would notice that in fly ash matters in air act, my lord, invariably writs are being entertained. I'm sorry, my lord, I'll assist as a student of law, my lord, but I'm finding it everywhere, my lord.
Now the question is that if some wrong or an illegality has been committed, will it be allowed to be perpetuated for all time to come? There is a time when the correction has to be done. Previously, if it is entertained does not mean that the jurisdiction is conferred.
My lord, there is no jurisdiction was ever taken away, my lord. In fact, my lord, as my lord's assistant, my lord, I would say that there are concurrent jurisdictions. There are not alternate jurisdiction. When, my lord, my lord.
So I have been looking at the provision of the NGT. It says an overriding effect that
overriding effect
civil court jurisdiction definitely. I was just thinking whether the NGT can be used like the other tribunal under Article 323A or B as a court of original jurisdiction, and then one can move and challenge the order as suggested in L. Chandrakumar before the division bench of the High Court.
My lord, the NGT says under section 22 that appeal would lie to Supreme Court. But I think, my lord, the L. Chandrakumar should apply. By judgments, my lord, the statute cannot be amended, my lord.
So that is why I say the L. Chandrakumar says that no, you can't straight away approach the High Court. First you go approach the tribunal and then the order of the tribunal can be challenged.
But 22 again, my lord, if we go by the statute, then 22 bars me to come to your lordship.
True.
22 says that you go to Supreme Court.
Yes.
22 of NGT.
That is the right of appeal forum.
That is Supreme Court, my lord.
Yes.
My submission is that, my lord, if I'm alleging that my fundamental rights are breached, and there's the issue of right of livelihood, right of Article 2119 violated. Still, my lord, the courts are so incompetent that no direction can be passed. And there is this is not efficacious remedy, my lord. It can be economic or something. This is not efficacious remedy at all.
In issue, any constitutional, all these things. It's very difficult. It's very difficult.
My lord, let the direction come, my lord. So the cost part is concerned, my lord, there are parameters fixed. My lord would accept the parameter, then well, otherwise, my lord, I will face the consequences. But CPCB
we appreciate the concern shown here, but we are still considering whether we should entertain or should not entertain.
Let there be an inspection at all. That's all, my lord. If they say that yes, in that eventuality, my lord, if they find out that the inspection was conducted and there is a breach,
then I remind you of
implementation.
I remind you of the Kiran Singh's judgment of 1954 Supreme Court. It says that if you lack inherent jurisdiction to entertain,
my lord is never lacking inherent jurisdiction.
Any order pass is a nullity.
My lord, the inherent jurisdiction cannot be rectified even with the consent. I'm not an inherent jurisdiction. There cannot be inherent jurisdiction.
No,
my lord,
approaching directly to the division bench without approaching the tribunal. That shows.
Well, for fundamental rights, my lord, my prayer D, and then my lord see my grounds. For fundamental, for even my lord, I'm losing my livelihood.
No, you are losing your livelihood. I understand it's the fundamental right. I understand. The moment you say is an infringement of a fundamental right, there is no difficulty.
Lord, I'm only giving the reasons. I have come before your lordship for my fundamental. Lord, I will say, Lord, that please don't pay me compensation. At this juncture, let there be an inquiry. Lord, otherwise, Lord, the time span would spoil everything, because I'm running against time. The damage is there.
What do you say, madam?
it's been the stand of the government, these cases should go to NGT. These cases should be going to the NGT, Your Lordship. Previously also, anything relates to water pollution or air pollution have all.
No, anything which is relatable to Schedule 1 of the NGT, it is desirable to go to the NGT. They do not want to travel to 400 kilometers from here.
Lordship's own.
Huh? Let me decide. Let me ponder upon the thing. I still have doubts. Let me clear my own doubts. I'll go through those judgments. I'm keeping this matter on Monday, and if necessary, I will dictate in the open court.
Deeply obliged. Deeply obliged.
Obliged, Your Lordship.
Give it.
Item note 22.
Yes.
Lordship, we have implemented the department and they have instructed the inspectors of rural range to cause an inquiry, Your Lordship. Seeking some time for the inquiry report to come to file a affidavit, Your Lordship. This is the instruction that I received today.
Oh, this is what, 42, 43?
Yes.
He is in 55, if I correctly remember.
Lordship, correct.
Huh?
Lordship's correct.
He has many customers at 43, and those are being eaten up by
42.
42. Granting more incentives, floating incentive schemes. Yes?
The Lordship.
Fine.
Why don't you go and make an inspection, whether it is at 43 or 44, 42?
2 weeks time, Your Lordship.
2 weeks. How far it is from here?
5 kilometers.
So,
Lordship, with inquiry a week and then we'll be filing an affidavit.
what affidavit? You just go there and just tell us whether it is there in 42 or 43. If you come and say it is in 42, we will not entertain. His petition has to go.
Next Thursday, Your Lordship.
Oh,
Thursday.
Thursday. So, record that she submits that the authorities have taken a serious note of
This is under the burger circle. And further to refund the 12 lakh rupees which has been seized from.
Is this power conferred upon the High Court? Or it is big power conferred upon the ordinary person? Transfer.
Yes, madam.
Is there?
Jurisdiction of plan has been, I mean, the order has been passed and jurisdiction of the assessee. The plan has been transferred from SCIT Sambalpur to ITO Baragar. The order has been passed.
So,
in the meantime.
Shipment, I have to refund my money within a stipulated time period.
why refund?
No, madam, it's a matter of search, madam.
Search and seizure, yes.
Right. So,
It will.
so demand is pending.
Since 2019, my money is being in your lordship.
So what? Now the case has not come to an end. And ultimately, if it is found that there has been, then in that event, or they will realize what? What?
Madam, that's what I have to tell the instruction because the source has been conducted and assessment is completed, but the demand is pending.
So what is then assessment must indicate that what is the demand?
Demand of the source was conducted, the amount of rupee
12 lakhs unaccounted, undisclosed amount has been seized.
Yes.
I understand.
Yes.
And then you have started.
Yes.
The assessment proceedings have been initiated.
Yes.
It started.
Yes.
Now you said that you have completed.
Yes.
Then you must have found. Assessment order must have reflected that what is the due and what should be the demand. You don't know.
No, madam, I have to do this person.
And then on the basis thereof, the demand would be raised.
I will take this person.
Okay.
Exactly the status of the present proceedings.
Liberty to move the authority, renewing.
Well, as I know from department, verbally that the petition has already moved to the ITT and that is pending before learn ITT.
For what? Challenging the assessment order?
Yes, madam.
Annexure 3 you have considered.
Yes.
This annexure 3 you have considered and this.
Yes, madam. That is for a jurisdiction, transfer of jurisdiction.
There is a transfer. This has already been done.
Sir,
Main prayer has already been addressed. Only thing is she wanted a refund. The money which was seized. So that is what I'm saying. If occasion arises, you can make a renew a prayer before the authority for refund. What we'll do. Yes. Record. Disposed of.
Item number 26.
Send it to brother.
In this case, the refund application is still pending since 19. Refund application is still pending since 19. They have not done anything. The Lordship directed.
What are you doing?
In this case, refund application has been, as per my instruction, as RBG 6 has been issued, which has been written sanction or rejection. So they have not attached this order with this petition. So we cannot know. I have to verify whether this has been sanctioned or rejected. Accordingly, my instruction is that it might be rejected because it's a 2019 file. And after that, after 3 years, they moved before the assessing officer to 3 or 4 years after that, my refund is pending.
So what?
So I'll be again verifying this thing, Your Lordship. If it more
Is there any period? Is there any period of limitation provided therefore?
The 2 years limitation is there.
What?
Applying for refund.
That period they find.
You are fined within 2 years.
Your Lordship, they have filed the refund application on 17/7/2019. An order has been passed on 27/9/2019.
So within 2 years.
So that I have to verify whether it has been rejected or sanctioned. It is that for reason it has been
Take
pending.
instruction next week. Take it.
I don't know, 27.
Yes. 2 weeks. Next.
Item 28.
May it please. This is a fresh appeal below.
Not the stale one.
Yes, sir. That's here. The rate petition was filed challenging the inaction of the IDCO authorities in not making allotment of the industrial land, which was in fact approved in my favor by EPCOL, which is a state case. It was approved in my favor, and it was also approved by the state level single window clearance authority, which is a high part body. So it was approved. It was still not being transferred or allotted in my name, that industrial. I have a Chhattisgarh based company with a delegation from the state government. They went to Chhattisgarh, met industrialists. They said, why don't you come to Odisha and invest in Odisha? Pursuant to that, I came, I did my due diligence. I said I will set up a iron ore beneficiation plant plus a pellet plant in a village, your lordship will kindly note, village HON'BLE, which is in Sundargarh under Koidar Tehsil. I conducted the due diligence. I took the report from the Tahsildar, and Tahsildar said that the property is available, that land is available with the government for setting up industry. It's available. I made an application to EPCOL Milots on 2/6/2023. Lordship, will kindly note this. 2/6/2023 I applied, 2nd of June 2023. Now, Milots, ultimately, state level single window clearance authority, the SLSWCA, gave the approval, Milots, on 31/10/2023. Let me kindly take page 139.
Whatever. Then what happened? What the decision has been taken?
Yes.
Tell me that what are. So according to you, the approval was granted.
Yes.
The land was identified.
Land was identified, approval was granted.
Correct.
At village for the village Bhanjepali. This is important. 10 millets, compliances, whatever for land and water requirement, I carried out. Project report, everything was done. EPCOL millets also writes to IDCO, recommending that this has been cleared by the single window clearance authority. Please allot this. EPCOL writes. And it also writes at page 161 that time is of essence.
Time is the essence of a contract. Then
Millets, IDCO also writes to me saying that please file your acquisition related documents. All of these things I file. I write to IDCO also saying Tahsildar has given a report that there is no encroachment. That report also I gave. Subsequently, Millets, that land is vacant. There's no question about that. Out of the blue, Millets, what happens? IDCO writes suddenly to me, Millets, which is at page 190. IDCO writes, the land that you have been pursuing, that land is not available for you. It is given to another company. Now, it is reserved for another company, which is 190, page 190 below. After such an advanced stage, after conducting all due diligence, everything, it has been approved by the SLSWC. And I'll also show the law which says the approval of the SLSWCA is binding on everyone. Now, here they write 29/12/2023, with reference to the subject, I am directed to inform you that EPCOL has recommended land measuring 56 acres of land at IDCO in the district of Sundargarh to set up 1.2 MTPA iron ore beneficiation plant and 0.8 MTPA.
When this land has been allotted to the another company mentioned there?
It is not allotted, Milad. They say it is allotted, but Milad, I'll show that. In the counter affidavit they file, they say when the writ petition comes up, in the counter affidavit, they say it has been given to Rungta Mines. Now, Milad, in that, I'll also demonstrate, Milad, how after this letter, kindly see, Milad, page 191. After that letter of 2912, there's another letter where at page 191, which is written by Executive Director Millards of EPCOL. There also, if he writes, the EPCOL Director, Executive Director writes on my behalf, saying that please, he recommends for allocation of a certain quantity of water for the plant that I'm going to establish. After that letter also, then Millards, page 192, IDCO also says, please deposit that 50,000 that you have deposited, but we are unable to locate it. Now, Millards, at page 195, we made a detailed representation.
Yes, then?
Page 195, we make a detailed representation on 22/7/24.
Yes.
In that, your lordship will kindly take page 196.
Yes.
196, the middle para. Further, we have received letter.
Yes.
Further, we have received a letter from your department with a letter number such and such dated 29/12 regarding submission of alternate land proposal for establishment of our industries, as the land we have applied for has already been filed under category A on behalf of Rungta Mines. In this context, we need a clarification that how is it possible that IDCO, being one of the designated signatories...
No, that you flagged an issue. Then how can it be done?
Is that flag?
Then,
Millards, it was never addressed. Then, Millards, at page 200, kindly see, Millards, 18/10/24, IDCO says that you give your alternate proposal once again. I have done all my Millards survey, my project report, my feasibility report, everything I have done corresponding to that particular patch of land at village Bhanjapali. What was approved for Rungta was village Kamanda. It was never approved for village Bhanjapali. It was never approved for village Bhanjapali. What is referred to in the impugned order is actually, Millards, the approval for village Kamanda. I have pointed out that there is no overlap. Rungta and my client, they can survive. One is at Kamanda, one is at Bhanjapal. There is no issue. Suddenly, Millards, on 2/6/23, I applied for this plot of land at Bhanjapali. 4 days, just 4 days later, Rungta has applied 6/6/2023. Rungta has applied for that particular land. And how is this application received? By hand. It is not by the GoSwift portal which is there. It is received by hand, and that endorsement is given. So all these things, Millards, I have highlighted, but Millards, what has happened? The impugned order says rights have already accrued in favor of Rungta, and therefore it's a fait accompli.
Give a notice. Give a notice.
I'm appearing.
You are appearing for Rungta?
Not Rungta. Rungta is not a party.
Yes,
Is one of the party. He is not a party.
No, I understand.
And the recommendation is earlier than him. of RUMTA.
No.
Yes, that is recorded in the findings of the court.
There must be some corroborative document that it was when the application was filed by him.
Yes.
Earlier to
That-
the RUMTA,
that-
earlier to RUMTA, as he says.
That
And-
document we have given in the counter. We have given.
And what is the modus operandi of
The RUMTA mines in
I am asking you, what is the modus operandi of making an application?
modern application
Is online application or
Online
is
application.
online?
Online
How can you receive a handwritten application and
not
put it in-
handwriting, not handwriting.
This is what he says.
What is that? Recommendation was
I am asking application by RUMTA, how it can be done on a hand.
not hand. He is making such allegation.
Or he's making allegation.
He is making allegation.
Which paragraph?
It is their counter that they filed.
Where page?
Page 252.
252. You are representing whom?
2, 3, 4, and 5.
I'm very bad in this name.
Sorry, IDCO.
Yes.
Well, that's one more thing I
There
must
is a
highlight.
Yes. Where is a
52.
252.
In office it was received.
7 June.
Yes. What is your explanation to this?
My lord, 237.
Yes, 252, sir. Please, come.
On 7th June 2023.
On the right hand side top of, there is a seal of your client.
Yes, that is there.
There is a diary entry also at the top.
Yes.
So it's a handwritten.
No, whatever is sent, also they submit the application.
Sir, I am asking, look at the.
He must have sent through email.
Your lordship, kindly see our counter governments.
No, not other way. You just
Counter governments.
that
He has disclosed this application in the counter.
They have filed it.
We have filed all the documents, recommendation by the IDCO also. That we have given. Page 237 it starts. Page 237.
Yes. We are at 237. Show us.
237.
Here below, there are state functionaries who are in my favor. I file a specific application before the single judge saying that please call for their affidavits. That is ignored. That IA was pressed, categorically pressed, that please call for affidavits from EPCOL, which is speaking in my favor. Also from the State Revenue Authority. That application is not taken up. I have pressed it and I have placed it in my written note of arguments also that I placed this IA where I have, Malaj will kindly see, this is also 263. Kindly see 263, Malaj, it's a very important document, Malaj, I wish to.
Let us see where you have said. Paragraph 4. No, it does not. Then. You have not said anything that the online application was filed by RUMTA.
That was not his contention there.
It was, I have, it's my written note, it's there in my rejoinder.
Lordship will find A by 3.
Yes.
Annexure A by 3.
Page.
Page. Page is in the counter, you will find that is two 237.
237, the counter starts, sir.
Yes, yes, counter.
I am asking, you are talking about this. I have already.
I have A by 3. You will have to kindly say. The allotment of land, then 245. For telling pond in favor of Mrs. Rumta Mines Limited, cover the project for capacity expansion of its integrated steel plant from 0.27 MTP to 0.9 MTPA at village Kamanda, district Sundargarh. In inviting to the above subject, I am directed to inform you that the High Level Clearance Authority HLCA in its meeting 21st meeting held on 9/1/20 had approved in principle the proposal of Rumta Mines.
You wanted where? Which village?
HON'BLE. This is for
This is Kamanda. That's why I asked. I have read it. Sir, this proposal was for Kamanda.
My lord, in approve the
Sir, again, the two things. This Kamanda was considered on an application which was filed into 2020 or prior thereto. And this is an application which is taken out in 2023. How can it be? How can it be? Tell me.
My lord, Rumta Mines application is earlier to him.
Huh?
It is for commander.
It is that before a birth can take place, immediately the right is created in his favor.
Your lordship kindly understand. The approval is given for the industry and that is recommended by a PCOR. Then
Sir,
in
that
approval,
is in
doesn't mean that, well, it does not mean that land is ensured for him. Because whatever is available in the land bank, then it will be given.
Fully appreciate, provided you do not discriminate any person, except had you said that we will not grant you a permission for this land, we have decided that we will not grant you a permission.
He is allotted other patch of land. Because
so, sir, you want to accommodate some cherry picking person, a very blue-eyed person, very palatable.
Not like
I do not know to the officer. We can't accept. No, we will not.
Your lordship
Will
kindly
not accept it.
Kindly see the documents one after another.
Maybe why you have chosen to do that?
In principle approved does not confer the right.
Absolutely agree with you. Provided your action is not discriminatory. You just say, I will not allot you this land, I will not grant you a permission. But when you say, I have already allotted to somebody else, and then if he is showed before us that how that man has been robbed in through a back gate, then it is a high time that he should be thrown from the front gate. From front gate. If he has entered from the back door, he should be shown a front door.
Keep it to another.
Can't be done. What are they doing? His application is earlier.
No. His application is earlier, not earlier.
Whatever. Everything has been decided.
It is not
Correspondences have been made. He is made to deposit the money. Everything is there.
My lord, that is a processing fee. That is not the whole of the land fee. First, that is a processing fee. Your lordship kindly
processing fees for taking a decision in respect of a land which he has suggested.
My lord, let me convince your lordship on the procedure. That procedure, if your lordship understand, then if a mere recommendation does not mean that this land is ensured for him. Because as per the availability of...
I will also convince you with some judgments that yes, what you say is absolutely correct on one state of facts, but may not be correct on the other state of facts.
That, my lord, let me...
Let us have, I will also as a lawyer, Let me
Right.
also
That is
prepare
right.
myself.
That is right.
Let us see.
That is right. But my lord, question is that, my lord, while it is recommended, then it is
Sir,
not
please,
known which
please.
land is to be given.
Please consider what you say is a too broad and a fundamental principles of law that we are making an application. Approval in principle does not mean that an inchoate right is created in a person. No doubt about it, sir. I have no doubts. Provided these principles will convince me. If you say that we have decided, though we agreed in principle, but we have decided not to settle this land or give this land to you, please submit some other land. We will not give you this. An alternative one. There was no quarrel on that. But once you say it has already been allotted to somebody else and it was wrongly given to you.
It is not given to him.
Oh, it
Not
was
to
wrongly in principle approved for you. In principle approved for you. Now you cannot be given there. He came forward and said that look how a circuitous route is being adopted by the authority to favor a particular person just to throw me out or done away with me. Applications was filed by me earlier, processed earlier, everything was done. Then from the back door, some application which is not in accordance with the procedure that was adopted, it was accepted, everything was done in haste. That inculcate also a sense that everything is not backdated or antedated.
My lord, I will convince your lord.
So do I. Both.
I will convince your lord.
Both.
Your lordship, keep it someday.
Tell me when. When? You tell me.
Relax. Huh? 20th lordship.
If
25th is my lord. My lord says 25th. We both agree.
Event chart was released.
Head chart were given in the written.
Just give a bullet points highlighting the malafide, which according to you is evident from the records. And give that, we'll consider. Don't worry.
25th.
25th.
25th, 2 p.m.
What is convenient to you, just
Rest of the matter will tomorrow.
Rest of the matters top of the list.
Tomorrow there is a difficulty, so it will spill over to Monday. It cannot go to Monday.
Top of the list so that
Above my name.